Good day, everyone. Today I'm going to discuss the Module 7, the legal correspondence. Introduction. Along with the other aspect of your job, a large part of being a secretary is creating type correspondence throughout the day. So the most common method of getting data from an attorney to secretary in most offices is by transcription device. Some offices still use shorthand, but most is not. Maybe because the transcription device can get all the information na sinasabi ng attorney than sa shorthand na minsan is nakakaligtaan yung ibang word, how to write in a shorthand way, tapos itra-transcribe ra, 'di ba? Mas madali nga naman talaga ang transcription device. Editing is a very important part of any secretarial position, particularly in the legal field. You would be hard-pressed to find an attorney who is not a stickler for perfect or nearly perfect editing, grammar, and spelling. In this module, you will know that editing is a part of work of a legal secretary. So if you are an secretary, you should be a have skills in editing. This article will cover various aspects concerned with legal correspondence, including getting signature, addressing judges and clerks, and dealing with business letters. Be sure to pay special attention to the information offered there. So this is the lesson will be held in this module. Transcription and the use of the recorders. Because of the efficiency, speeds, and ease of using transcription over other methods, it has become the standard in the legal field. The system essentially works this way. The attorney records a day's worth of several days' worth of documents into a handheld recorder with a removable tape. The attorney includes names, courts, cases, motion of various types, and all relevant information before each new document to be typed. The tape is then handed over to the secretary, who uses a tape player with a headset. As the secretary goes through the tape, she types each document in turn and complete the day's worth of work. When finished, the tape she places the tape in a done bin and proceeds with an editing and printing of each document. After mag-record ng attorneys, it is work for the legal secretary to transcribe it and type it, and after that yung tape na ginamit natapos niya nang i-transcribe or i-type is ilalagyan niya ito ng word na done para in order for the secretary na hindi niya na in order for the secretary na alam niya na tapos nang matranscribe yung nasa tape na yon. These are given to the attorney for review. The attorney will sign off on those that are ready for sending, edit, or add information to those that need it, and return this file to the secretary. If nothing has been missed or misinterpreted and the attorney no longer needs the tape, the secretary will then erase it by sliding it under a magnetic tape eraser. So, after type and magbigay na ng secretary yung tape na yun or yung na-type ng niyang nasa tape is ibibigay niya ulit dun sa attorney in order for checking. Then, if pag na-check na ng attorney yon, titignan niya kung meron pa bang pwedeng idagdag or basta is check niya yung ginawa mong pag-edit dun sa basta i-check niya yung ginawa mong pag-edit dun and magdadagdag siya or kung wala naman na siyang idadagdag, the secretary can delete it. It may then be wound and placed into the blank tape bin. And after all the process or kapag natapos na yung isang tape na na-record ng attorney na yon, na type mo na check niya na, then it's already done. Sabi ko nga, you can delete it and the tape recorder, you can use it, you can, mag 'di ba pag dinilit mo na yon, the tape will be blank again. We can that in order for you na magagamit mo pa ulit Yon. There are several important points should be remembered when using this system. Number one, if you cannot understand something the attorney said on the tape, even after replaying it multiple times, ask him or her to clarify. So yon, first thing first, if you don't understand or if you think na hindi mo or it is jargons to you na yung word na yon or you are not sure kung anong word ba talaga yon, you can ask the attorney ano kung ano yon. Wala namang masama sa pagtatanong doon. Next, number two, double check any names you are unsure about for proper spelling in your address book or municipal law book. So as a legal secretary, you have the materials or the files of every clients you have. So kapag narinig mo yun dun sa recording, you should double check the names of your clients, especially on the spelling, in order to, hindi magkamali. Yun. Number three, never erase a tape until all documents on it had been approved and prepared for sending. It is one of the most important din kasi, paano kung na-delete mo yung recording na yun, you can change or you can go back in time. So, you better make sure na natapos mo nang i-type yon and na-check na ng attorney yon, and better kung mas maganda kung i-delete mo na yung mga files kung na-send na or done na yung case na yon. Number 4, be sure to label your tape bins clearly and keep the incoming bin on the opposite side of your desk from your completed and erased bin. This avoid tape mix accident. So tape mix accident is mahirap kapag nangyari to. Kasi lalo na kapag hindi mo nalalagyan ng mga names or maganda kung hiwa-hiwalay yung mga tape bins mo. Kunwari, yung mga blank tape mo is nakahiwalay dun sa mga ongoing cases or dun sa mga new cases. Number 5, keep recorder batteries and fresh tapes handy at all times. So, as a legal secretary, you should keep batteries of recording or recorder device and always make sure na hindi low-bat and always make sure that it's functioning. Number 6. For every long documents, information may be recorded on two or more tapes. Be sure to keep this together by securing them together with an elastic band. So, sinasabi lang dito na sometimes one recorder is not enough in one cases. Minsan umaabot ito ng 2 or more tapes. So if it's happen, you should use elastic band to band the 2 or more tapes. 7, and last, you may receive several tapes in one day. Since tapes come with only one top label and are reused multiple times, small post-it notes may create temporary labels for reminding you of the case or date of each tape. Sinasabi lang dito na you can use post-it notes na to be palatandaan because sometimes sa sobrang dami ng tapes na kailangan mong i-transcribe, i-type, or i-edit or maybe sometimes pag nagkasabay-sabay maraming mga tapes na kailangan i-edit para hindi ka malilito. The type of recorder, headset, and player may vary from attorney to attorney, but the procedure is essentially the same. If you do not have experience with this system, do not worry too much about getting the process down perfectly. You will become more adept at this process with practice and as you learn your particular attorney style, voice cues, and way of the recording. If you so desire, you can rent or borrow or purchase a recorder and practice typing recorded data. The importance of thorough editing. Editing is a vital part of legal secretary's position and should be taken very seriously. Thus, some basic editing tips are included here. We will cover resources that are available that will help you become a top-notch editor. Most of us who use a word processing program with any regularity have become accustomed to relying on the spell check feature to catch certain errors. However, it would be a huge mistake to allow this feature to serve as your only means of editing a legal document. So, we are really relying on spell check on the word processing, right? So, minsan kasi hindi lahat ng mga words dun sa spell check natin sa word processor is nade-detect niya lahat ng mga errors. Sometimes, yung mga pangalan is ginagawa niyang error, but it should be yun talaga dapat, 'di ba? Spell check does not catch all spelling errors because of a word in question might be spelled correctly but still be incorrect in a usage. Yun nga, katulad ng sinabi ko kanina. Additionally, a computer spelling check cannot check proper names for you, so double check those yourself. So, yun. Katulad ulit ng sinabi ko kanina, na dun sa word processing na spell check, yung mga names sometimes hindi niya bine-verified yun and naka-red talaga siya kasi wala naman talagang word na ganun kasi pangalan yun, 'di ba? Pangalan yun, 'di ba? So, I think kailangan mo pa talagang i-check yun ng sarili mo. Isa-isa. Ganon, 'di ba? Editing may seem like a time-consuming part of your job, but if but it ultimately will save time in the long run. Editing entails reading the document over, top to bottom, and looking for mistake in spelling, grammar, punctuation, and typing that may be present in the document. Putang ina. Editing truly before printing is extremely important. If you miss a mistake, it is a guarantee that your attorney will catch it and you will have to correct the error and reprint the document before he will sign it or let you prepare it for the delivery. So before printing the document, it should check it truly, especially on the spelling, grammar, or so on na bago pa man mapirmahan ng attorney yon or ma-deliver dun sa clients or sa kung saan-saan pa. To error is human. However, too many errors and your attorney will become frustrated. This will be this will do nothing for your career and may even cost you a good reference of your job. So the document will reflect to you. Pag mali-mali yun, maybe it will reflect to your reference as a legal secretary. Edit, edit, and edit again. Before printing anything, edit one last time after printing and handing the document over to your boss. So all you need to do is edit and edit and edit before printing and before the document go outside. In order for you or for your organization na merong good image. If you have an office or cubicle body, see if you can set up a reciprocal editing partnership with her or him. Offer to do a last double check of your office body's document before she or he hands them over to the boss and vice versa. So, it is a good teamwork to do na kung meron ka mang kung meron kang katrabaho, you can ask him or you can ask her to check your work or to double check your work para maiwasan yung mga pagkakamali bago mo maipasa. And ganun ka din sa kanya para vice versa kayo. This often helps because when typing very large documents that have been edited and changed multiple times, a fresh eye will see errors that often are missed through overexposure. Be prepared to make multiple changes to any given document after it has been looked over by your boss. particularly during the draft stages of preparation. And be aware that you must perform an edit check for spelling, grammar, and typos before printing for each and every draft. This is a vital part of your job. It is embarrassing for an attorney to send out documents with errors. It makes the attorney looks bad and makes you appear incompetent. Therefore, edit, 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 and edit one last time. Your boss will greatly appreciate you for doing it. Katulad ng mga una ko pang sinabi, kailangan talagang i-check yung mga documents before it came to the process of printing. And also, i-edit ng i-edit kasi lahat ng mga documents na ginagawa mo as a secretary, lahat ng mga papers na ginagawa mo, it will reflect to you. Actually, not only you, but also into the organization where you're working at. And isa pa is nakakahiya naman sa attorney or dun sa boss mo na magbibigay siya ng mga document or papers to his or her client na mali-mali. So the attorney will be look a bad or it will look incompetent because of your wrong doings or sa pagkakamali mo. Ganon. A note about editing and your resume. Your resume and cover letter will be your first introduction to the attorney or firm you are interested in working for. Because of this, be sure that both exceptionally well written and scrupulously edited. So, in this, dapat sa paggawa mo ng resume, if you are applying for a legal secretary, dapat nakikita na yung skills mo in editing because it has a lot of big points to the attorney kasi yun yung pinaka-more na hinahanap nila. Correspondence to judges and clerks. In all correspondence to judges, cover letters and envelopes should be addressed this way. The Honorable John J. Jones, Justice Appellate Division, or whatever division the judge represents. Supreme Court of the State of X, followed by the address. The salutation should read, Dear Judge Jones. Names you are not sure of should always be double-checked for proper spelling. So, ganito yung na-address yung mga judge and clerks when you are sending papers or the documents. Ganito naman ina-address yung mga clerks. In all correspondence to clerks, cover letters and envelopes should be addressed as follows. Clerk of the Appellate Division or whatever division they represent. Then the address of the court. The salutation should read, Dear Sir or Madam. You may often have to include a self-addressed stamp, envelope, or sachet when sending filings to a court clerk. This sachet will help you and the clerk and to ease their work na para alam nila kung kanino yung letter na yon and kung para saan or kung tungkol saan, kung kaninong kaso, mga ganun. This gives the clerk a convenient method of sending copies stamped filed back to you. Be sure to add this item to your number of enclosure and do not forget to stamp the envelope. Getting filings without a pre-stamped sachet is a fib of most clerks. Of course, kapag walang sachet, mahirap para sa mga clerks yun. Kaya, yun yung kinakagalit talaga nila. If you are ever unsure about the appropriate fees or number of additional copies that must be provided with any given document and cannot find this information in your municipal book, call the clerk office and ask. Hindi ka sigurado kung ilan yung ipoprovide mong mga documents for the one case, you can ask the office clerk or you can call it. Clerks are required used to answer this question, and as long as you are polite about it,
They will be more than happy to tell you what you need to know. It often helps to keep track of fees and copies as you discover them. Type this information in your computer or write it down on a legal pad or notebook. That way you have to ask only once.
And no matter what legal document the writer is preparing, the theory of writing remains unchanged. Use existing material and authority to create new documents. This concept is very important for two reasons. Use forms or templates. The document being created has most likely been created before. By using a previously existing form or template, the paralegal not only increases the likelihood of producing a quality document, but also produces it in a more efficient manner, saving the client money. This applies even in the creation of such mundane documents as a client's retainer agreement letter or a request to a hospital to provide records. Use existing documents such as forms, form books, and templates to create new, modified documents. Don't reinvent the wheel. So in this, kahit na mga maliliit na bagay na mapapel-papel lang yan, kailangan ihingi mo to o request mo to dun sa pagkukuha na talaga. Hindi mo siya pwedeng pekein or gumawa ng sarili mong ganon and kokopyahin mo lang. Wag na wag mong gagawin yon. Precedence, second, by using existing authority as a basis for a legal analysis or argument, the document gains weight in terms of its legal reasoning. That is because what the court cares about when making ruling is law and only the law.
What the lawyer or paralegal thinks is irrelevant. All that matters is the law. The advantage to the paralegal is that the use of the reasoning from existing law takes the pressure off the paralegal to create that reasoning for him or herself. It makes the process of legal analysis easier to accomplish and result in a more authoritative document. In other words, you don't have to create the law. You simply find and apply it. Each type of legal writing has a specific function. This chapter will concentrate on the preparation of the legal memorandum, but it is helpful to be able to distinguish the function of different legal documents. Correspondence, letters and emails between attorneys or paralegals and clients make up the bulk of correspondence. There may also be correspondence with witnesses, businesses or agencies, or even potential adversaries. So correspondence are not only for the judge and clerk, marami pang ginagawa ng mga correspondence. There's a lot of correspondence to do kapag merong kasong ginahawakan. Pleadings. These documents are generally fact-based, not law-based. The writer prepares documents that lay out specific facts that support his or her position in litigation or criminal proceedings. It is in motion and at trial that the law is applied to the facts in the pleadings. Discovery. These documents are also fact-based, not law-based. The primary purpose of discovery is to expose facts relevant to litigation, such as what really happened or what witnesses the opposition intends to call during trial. There may be requests, however, for the law that the opposing party intends to argue at trial. Motions. Motions such as for a summary judgment seek to have the court address a procedural issue. Briefs and memoranda. These documents argue legal issues and are, therefore, law-based. Internal memoranda such as inter-office memorandum are objective, looking at both sides of the legal question. The external memoranda such as trial briefs attempt to persuade the reader and only argue law that is favorable to the client. Correspondence. The initial correspondence with either a client or the opposing party establishes a tone of professional communication. The initial correspondence with the opposing party is often a demand letter. The initial written correspondence with the client is some form of update regarding initial step being taken by the law firm in the client's case. The demand letter. There is no single correct form for a demand letter and no statutory requirements that must be followed. Some states have specific rules covering demand letters in collection cases, but a demand letter should always inform the recipient of the matter in controversy and the sum of the money demanded. A demand letter is a part of the concept called exhaustion of remedies. This means that all the stages of a given dispute, every reasonable solution or remedy has been tried. A good demand letter can fulfill this obligation. The demand letter, basically, the person who eventually files suit in the court wants to be able to say, "Your Honor, I tried to ask for my money without involving the court. Here's the demand letter to prove it." In some jurisdiction, but not all, adherents to this concept can go a long way toward establishing an argument for the award of attorney's fees. If the amount of money won at trial exceeds the amount requested in the demand letter, the argument for attorney fees is much more likely to be successful. The following are the elements of a successful demand letter. Number 1, be clear and straightforward. Number 2, do not argue your client case in the letter. Number 3, provide documentation to establish the claim. And number 4, provide documentation to establish damages. So first, be clear and straightforward. Sometimes less is more. Don't get bogged down in the details. The paralegal does not have to provide exact details and facts. Most importantly, never make up numbers or facts and never embellish information. So this is the example. Kunwari, nagkaroon ng car accident. So don't provide the estimated speeds ng car na nakabangga and yung mga car models and yung time and the weather condition.
Just direct to the point, kunwari ganito. On January 17, 2005, Mr. Hayes ran a red light at the intersection of the Main Street and the 2nd Street, causing a collision with Mr. Jones. Huwag mong ilalagay yung pangalan ng mga nakakita or ng mga witnesses. Okay? Next is don't argue your client's case in the demand letter. In other words, don't feel as if you have to prove your case in the demand letter because you don't. Argument involves explanation, reasoning, and conclusion. Not only is arguing not required in a demand letter, providing argument on your client's behalf might give away strategy the attorney intends to use at trial. Alam naman natin na letter to, so you should not argue with the opposing party. Dapat hindi mo pinapakitang galit ka. Hindi mo kailangan i-prove yung sarili mo kasi alam mong ikaw yung tama, ganun. Next, provide documentation to establish the claim. The claim is the reason for the controversy while not required in a demand letter. Documentation can act as a shot across the bow, making the opposing party aware that the matter is serious and probable. Dito, you will see the documentation how powerful it is. This is the example of how documentation use. If an escalator malfunctioned in a department store injuring the rider, the claim is a failure to properly maintain the escalator. Documentation of the claim might include a witness statement. If a passerby is injured when he steps on a rollerblade left on a sidewalk in front of the house, the claim is the negligence of the homeowner. Documentation might be a picture of the scene, including the rollerblade. A store sells a defective product and refuses to provide a refund or replacement. The claim is defective merchandise. Documentation might include the sales receipt. So, not only the pictures and video ang mga documentation. It also includes the sales receipt, katulad nun dun sa pangatlo and sa pinakalas na example. Documentation's only role at this point is to establish that the event occurred. Don't try to prove your case in the demand letter. If there is extensive documentation available, don't feel like all of it must be disclosed at this stage. Be minimalist, only provide enough to establish the basic claim. Number 4, and the last, provide documentation to establish damage. Documents to establish damage in a demand letter are more important than those establishing the claim.
No money will be granted at trial unless damage can be established. If the documentation provided in the demand letter is clear and reasonable under the circumstances, the other party may choose to pay the damage without a lawsuit. Receipts, invoice, bills, accounting statement, and hospital record provide excellent documentation. In this, kung sa una pa lang maayos and maganda yung demand letter mo to the opposing party, hindi na kayo aabot pa sa lawsuit. The client letter. When a client has complaints regarding legal representation, the dissatisfaction often cites the lack of communication between the attorney and the client. A paralegal can assist in maintaining frequent and clear client communications. As a general rule, when a paralegal communicates with the court, such as when filing legal documents, the opposing counsel or witnesses regarding the case at some point, he or she should notify the client of this communication, preferably in writing. A copy of correspondence should be included in the letter to the client. Some firm ask the paralegal to give monthly updates to the client, which serves the same purpose. Consistent communication will help prevent misunderstandings, help the client understand the representative process, and encourage him or her to feel more involved. The letter should not be long, and it does not need to explain the reasoning behind every action taken on behalf of the client. It is important to be professional at all times. Attempts to be humorous of body can be misinterpreted and maybe appeared unprofessional. Even if the relationship with the client is relaxed and good-natured, in your written correspondence, you should impart the persona of a legal professional. Email communication. Every law firm now communicates with clients, witnesses, opposing counsel, and employees via email. Since the invention of the telephone, it is arguable that no other tool has now altered the way people communicate with each other. So in today's generation, all people really rely on email communication. While every firm will have its own personality and policies, the following is presented as advice on how to be professional in your email correspondence. So follow these rules of email etiquette. Number 1, identify the subject matter. Number 2, identify yourself. Number 3, keep your email format simple. Number 4, use appropriate capitalization and punctuation. Number 5, keep message short. Number 6, limit use of abbreviation. Number 7, avoid using emoticons. Number 8, never yell in your email. Number 9, be polite, patient, and appropriate. And number 10, you may be called to account for your emails. So the following rules of email etiquette will help your email to look like professional. So that's all the legal correspondence, and thank you for listening and watching.